We have seen the Gen Zs. Very many were abducted. The government has come out saying it has never abducted anybody. Who can believe the government? Listen the PSS. Listen the Inspector General of Police. Listen the DCI. Listen any police officer who is joking with the law. The judge is telling public servants that political power and public power is transient. It comes and goes. Today, you're in power. The Gen Zs are being shot left and right. You do not mind. Power is transient. But the rule of law is permanent. That's what the judges say. And remember, the judges have now said from the Court of Appeal, you will be held liable personally. Welcome to Court Helicopter Explainer, where we are dealing with issues of public officers. The week has been a lot of issues about public officers. We have seen the PS for youth being embroiled in a tussle. What is the law that deals with public officers? We have seen many public officers, especially police officers, arrest citizens, lock them in because they have been told to arrest and lock these people in. The law talks about being detained for 24 hours. But sometimes calls are made from above and a citizen is detained for a long, long time. We have seen the Gen Zs. Very many were abducted. The government has come out saying it has never abducted anybody. Who can believe the government? Who can believe that the Gen Zs have not been abducted by government? The question every Kenyan is asking, how can somebody abduct himself, beat himself up, injure himself, cause serious, grievous bodily harm, take himself to hospital, to the Kenyatta National Hospital? Many of the Gen Zs died. This narrative of self-abduction is the narrative that was there when the late Foreign Affairs Minister, Dr. Ouko, died. The narrative was that he committed suicide. The body of the Dr. Ouko was heavily mutilated. He was bludgeoned to death, and a gun was placed around there. So the question that was there, did he mutilate himself, torture himself, then shoot himself? That narrative was not available until the Scotland Yard was invited. The Scotland Yard is the CID or the CIA equivalent of the Americans or the CID equivalent of the UK. True, a detective from Scotland Yard came and dealt with that issue. It was a political question. It was covered under the rug. So the question of when public officers misbehave was placed before Justice Ngugi J when he was in Nakuru before he was elevated to the Court of Appeal. Justice Professor Ngugi J, a judge of the High Court then, now a judge at the Supreme Court. This is petition number 38 of 2014. It went to the Court of Appeal, and that is in Civil Appeal number E030 of 2020. What were the issues in this matter? Let us see what happened. In this matter, the police officers arrested people and detained them for more than 24 hours. In the pleadings that we have here, the petitioners are citizens of the Republic of Kenya and residents of Nakuru town. They allege that they were arrested and held beyond the constitutionally mandated period of 24 hours. They were eventually charged at the Chief Magistrate's Court in Nakuru. The petitioners were subsequently acquitted by the court on the 31st of October 2013 under Section 10 of the Criminal Procedure Code, after the learned trial magistrate concluded that the prosecution had not established a prima facie case warranting the petitioners to be put on their defense. Brief facts of this matter is that after they were released, they sued the police officers by their names. They said they were used as sacrificial lambs, that the real target was Honorable Luka Kenyan, the member of parliament that time, who had differences with the first respondent. They claimed that the act of disinterment was actually done by the office of the first respondent and that their arrests were baseless. They claimed that the first respondent wanted them to falsely confess that it was Luka Kenyan Honorable who had disinterred the body and that they were only charged when they refused to do so. They were charged with the offense of exhuming a body and detaining that body and discreting on that body. So they went to court. The following petitioners, Kimunai Ole Kimeiwa, Dana Shitiva Daudi, Sylvester Kibet Totona, Musa Chemitei Kipkamba, Amos Kibet Konyai, Francis Mungai Thuo were arrested and charged for the offense of having exhumed a body and defecated on that body. They sued Joseph Motari Musigisi, the then district commissioner, Rongai district. Then they sued the district criminal investigating officer, Nakuru district. They sued the principal secretary, Minister of Interior, Coordination of National Government, the present position held by Omolo. What did the judge say? The judge found them guilty and ordered. He said, in the present case, there is no question that the petitioner suffered immense trauma at being locked up, charged with disrespecting the dead. Their names were published in at least 2 national dailies produced in court, leading to humiliation in the eyes of the community. Taking all into consideration, I'm of the view that each of the petitioner is entitled to compensation in the sum of Kenya shillings 800,000 for the ignominy they each suffered. This is Professor Joel Ngugi on 16th January 2019. So the judge found out that the public officers, the DCI boss, the PS for internal security, and the county, that time the district commissioner, must pay from their pockets. Aggrieved, they went back for review in the same judge. They filed an application for review in the same judge. What did the judge say? In paragraph 13, the judge says, in the case at bar, the court considers the facts of the case and the law and announced a rule of law that a public servant who travels outside the remit of his office and acts maliciously towards his fellow citizens and thereby inflicts actual injury or emotional distress to such citizens loses the personal protection and immunity afforded to him by virtue of a public office. Such an official is, in the famous tort speak, on a frolic of his own. On such a frolic, he should expect consequences of his actions, consequences which are not inoculated by either the Constitution or statutory law. The judge proceeds and says, in announcing and applying this rule of law to the case at bar, the court was reminding all public servants, listen the PSS, listen the Inspector General of Police, listen the DCI, listen any police officer who is joking with the law. In announcing and applying this rule of law to the case at bar, the court was reminding all public servants that their offices are clothed with the public power to be exercised in accordance with the Constitution, the law, and the oath of office. Public officers should not excitedly and maliciously exercise power at the behest of the politically powerful to harm those perceived to be on the wrong side of the political divide at the given political momentum. The rule of law this court announced and applied was to remind public servants that political power and public office are transient. The judge is telling public servants that political power and public power is transient. It comes and goes. Today, you're in power. The Gen Zs are being shot left and right. You do not mind. Power is transient. It comes and it goes. But the rule of law is, by our Constitution, enduring. The arc of history might be long, but it unfailingly acts towards justice. Justice Ngugi again dismissed them. Aggrieved with the decision of Justice Ngugi, they went for civil appeal number Nakuru E030 of 2020. This is the appellant was Joseph Mutari Musigisi. At that time, he was the then district commissioner, Rongai district. He had been ordered to pay the people he arrested 800,000 shillings. The judges who had this matter were the judges of the Court of Appeal. And the Court of Appeal, this is Justice Warsame, Judge of the Court of Appeal, Justice J. Mativo, Judge of the Court of Appeal, and Justice M. Gashoka, Judge of the Court of Appeal. This was a decision dated 17th day of March 2026. This year, what did the judge find? Accordingly, it is our finding that this appeal is devoid of merit. We dismiss it with costs to the first to the sixth defendants. So the Court of Appeal upheld the decision of Justice Ngugi. What are the lessons learned from this? One, that political power is very, very transient. Today you have it, tomorrow you are out of office. Two, public office. Whenever you have a public office, whenever you have been appointed a CS, you have been appointed a PS, you have been appointed an IG, a DCI, a police officer, a prison officer, a director in any arms of government, you know that power is transient. But the rule of law is permanent. That's what the judge is saying. And remember, the judges have now said from the Court of Appeal, you will be held liable personally. We did an explainer where we said His Excellency Rigathi Gachagua should sue the senators in their own names. Personal liability. And everybody was laughing. How will senators be sued in personal liability? The Court of Appeal has affirmed that decision. If you misbehave as a public officer, if you misbehave as a government officer, if you do not follow the rule of law, you will be held in liable as a person and you'll pay from your salary. Wakili Dan Omari, a pleasure. Thank you.